The rule of law at play and not the rule of might in Rivers State, as the Supreme Court reinstates Amewule-led assembly, stops allocation to Rivers State to restore constitutional use of funds, and removes all local government chairmen elected in the state's 2024 poll. Good morning. Thank you. Good afternoon. Thank you so much for joining us. This is That Point. I am Precious Amayu. The Supreme Court of Nigeria has ordered the Central Bank of Nigeria, the Accountant General of the Federation, and other agencies to stop releasing funds to Rivers State government. And that's until Governor Fubara represents 2024 appropriation bill before a legitimate assembly led by Amewule, who got reinstated. The Supreme Court also annulled the local government election conducted on the 5th of October 2024 by the Rivers State Independent Electoral Commission, saying it grossly violates the Electoral Act. In reaction to the judgment, the Rivers State Governor, Siminalayi Fubara, says he acknowledges the Supreme Court's decision to reinstate the 27 lawmakers, but he awaits a detailed briefing on the implications of the judgment. And the Minister of the Federal Capital Territory, Nyesom Wike, praised the judiciary for standing firm against what he described as impunity in Rivers State.
The court said that no money shall be released to the state government until a lawful appropriation law is enacted under the Martin Amewule-led House of Assembly. In a lead judgment delivered by Justice Emmanuel Alguim, the Supreme Court also ordered the 27 members of Rivers State House of Assembly to resume duty immediately. The unanimous judgment of the 5-member panel of justices led by Justice Owani Abaoji faulted all actions carried out by Governor Fubara for being unlawful. The Apex Court took a swipe at the governor for engaging in criminal activities of demolishing the House of Assembly with impunity just to prevent 27 legislators in the House of Assembly from sitting to carry out lawful activities. Justice Alguim ordered the clerk and deputy clerk, which were unlawfully redeployed out of the House of Assembly, must be allowed to resume work alongside the House of Assembly workers. The court held that it was an aberration for Governor Fubara to operate with only 4 out of the 32 House of Assembly members under the guise of baseless fears that he would be impeached. According to the justices, Governor Fubara, by his unlawful acts amongst others, collapsed the House of Assembly and used his immunity under Section 308 of the Constitution to carry out unlawful acts against the rule of law. A sum of 10 million naira fine was imposed on Governor Fubara to be paid to the House of Assembly and the 27 members who instituted the suit against him. In another judgment, the Supreme Court invalidated the local government election conducted in Rivers State on 5th October 2024. The Apex Court held that the election was invalid because all conditions precedent that should have been implemented were jettisoned by the Rivers State Electoral Commission. Specifically, Justice Jamil Utuku, who delivered the lead judgment, held that the council poll was conducted in gross violation of Section 150 of the Electoral Act of 2022.
It has come to show us that all the political caricature in Rivers State must come to an end by this judicial decision. It has come to confirm that the only valid member of the House of Assembly are the 27 members under the leadership of Martins Amewule. It has also come to confirm today that there has been no government in Rivers State all this while, because the 3 arms of government must work together effectively. For the past 1.5 years, the Rivers State House of Assembly, which is an arm of the government, have been set aside. The implications are real. All the appointments confirmed by the House of Assembly, all the laws passed, all the budget passed are invalid. That is the essence of this election.
A member of the Apex Court justices who delivered judgment in their appeal in respect to the conduct of local government election, Justice Emmanuel Alguim, said there is a new trend by the court to ensure the promotion of the observance of the Constitution and the rule of law.
Speaker Martin Amehule presided over plenary few hours after the latest court decision on the politics of Rivers State. It started with the leader of the House officially drawing the attention of the legislature to the development.
The purported local government election that was conducted in this state was also nullified by the Supreme Court. So, Mr. Speaker, today is a great day for democracy. Today is a joyous day for Rivers State and the 10th Assembly.
For the lawmakers, the Supreme Court has upheld the principle of separation of powers and respect for the Constitution.
The Supreme Court has ordered that the revenue accruing to the state should be withheld. Honorable members, this is a victory for democracy. It's a victory for the rule of law. And this goes to show that indeed we have three arms of government.
With the fate of local government officials now hanging in the balance, the Assembly is warning against looting of government property in the council offices.
As it stands today, those persons who were illegally in our councils as local government chairmen and councillors have been asked to vacate until proper elections are conducted or the needful is done. The Supreme Court has given their judgment today, and with that judgment, it clearly shows that we have been right all along.
Outside, supporters of the lawmakers were celebrating the outcome of what has been a long-drawn battle in court.
Whenever there are judgments like this, there is no way it will be favorable to everybody. But because we run a constitutional democracy, whether I like the judgment or not, we should be able to abide by it. That's my pride. Generally, we're happy. The state is happy. You can see that everybody here is happy because of the judgment.
The House of Assembly's message to the residents is to maintain peace as they await other Supreme Court judgments.
All right, thank you so much for staying with us. You saw that the breakdown of that judgment and the different reaction to that judgment. All right, let's talk more about that judgment. Here with me to analyze what this means for Rivers State political landscape is constitutional lawyer Chinobiago San. And also joining me, all right, we will have another guest join us from Port Harcourt anytime soon. We will bring him on when he joins us. All right, let me start with you, Mr. Obiago. We've seen different, analysis of this particular judgment, but let me ask you what you make of the judgment coming from the Supreme Court.
Well, thank you very much, Precious. Actually, I've not seen the full copy of the judgment, but from reports coming from the media and analysis right in the court premises by your correspondent. I personally think that the Supreme Court was right in sanitizing the unconstitutionality, and the rascality, with all due respect to all the players going on in Rivers State. I mean, it's an aberration that in a House of Assembly of 31 members, 4 persons will pass a law or resolution. The Constitution says it must be either a simple majority or 2/3 majority, depending on the contest. So I think all along, that unconstitutional actions has been taking place in Rivers State. And we are right that the Supreme Court, being a policy court, has reinstated the importance of the rule of law and compliance with the Constitution. So I think the judgment is correct, very accurate.
When you say illegality, because just before this time, there were those who were supporting the governor, even who were not even in Rivers State, and they were supporting based on, maybe the political side of things. But does this put to rest even the politics of this matter?
Yes, of course. You know that sometimes when people are fighting, the public tend to support the underdog. So a lot of people think that Governor Fubara was an underdog because his godfather is trying to impose himself on him. And that's why he got this, well, if you look, emotional support. But emotions and law are separate apart. Now, the law is straight about how to pass laws in the assembly and how to demember a member of House of Assembly. If they had defected to another party, of course, under the Constitution, they lose their seats. But there was no evidence, according to the judgment, that they have defected from PEP to APC. And that was very strategic for those members. And insofar as their seat had not been declared vacant, they are subsisting members of the House of Assembly. And you cannot bypass the majority to pass a law, no matter how much political support or how social support or popular support you get, because that is the law. The same with the local government elections. If you don't comply...
we would take them one after the other, okay. But I want to bring in our guest from Port Harcourt. I just want to get that designation correctly. The president of Citizens Quest in Port Harcourt. Sorry, Citizens Quest for Truth Initiative of Biaruko Undukwe. Good to have you join us. Mrs. Undukwe, can you hear us?
Yeah, hello.
All right. So I just wanted to also get to we've been speaking to the lawyer in the studio. We've seen different reactions coming from both lawyers and politicians. But what's your reaction to that Supreme Court judgment?
Hello, can you come again?
I was asking you your reaction to the Supreme Court judgment.
Okay, my reaction. Well, my reactions are not different from what it has always been from the onset of these issues. I've always maintained the position that the law will always speak, and when the law speaks, the noise will be less. You know, the truth of the matter is that the Supreme Court did what I expected long ago. The Federal High Court had given judgment, and then, of course, the appeal court upheld the judgment of Justice Omotosh. And then the Supreme Court did same. If you look at the statements, you know, the judgment coming from the Supreme Court, you will see that it's not less different from what the appeal court did. You know, it was very clear. And of course, that's what is expected, that the judiciary should be able to settle where there are issues between the executive and the legislature. The judiciary should come in and then do the needful. And I think that that's what we see that has taken place. But in any case, like I told some persons, it's not about Governor Sim, it's not about Martina Mehule or Wike or anybody. It's about democracy, it's about the rule of law over the rule of might, and it's about every arm of government working in synergy. None should muzzle the other. You know, and this is a precedent that has been set for every politician, even intending ones, and then all those who are, you know, hoping that they could use any aspect of the law to intimidate others. You know, so for me, it is a welcome development. It is what we expected, and for me, the game is over for everyone who has been pretentious about these issues. So let governance begin. Let a proper government be formed, because the Supreme Court made it clear that there's no government in Rivers State. And I kept saying that government is not about the governor alone. The legislature is part of governance. The judiciary is also part of governance. So let everybody go back to their duty post and get the job done the way it ought to be. So for me, it's a good one.
All right, so let me come back to the studio. You were talking about the 27 lawmakers. One of the things that the governor said yesterday through his commissioner for information is that there is still a case in the High Court in Rivers State concerning the defection of these lawmakers. And so this doesn't legitimize, that this particular Supreme Court judgment doesn't legitimize the lawmakers pending when that suit is heard at the High Court. I mean, what's your reaction to that?
No, that can be. The Supreme Court is the appeals court, and the Supreme Court has pronounced that the Rivers State Assembly is composed of everybody, 31 members, including the Martins Amawule's faction. So if there's a pending matter in the High Court, it cannot even be used to stay the execution of judgment of the Supreme Court, because the Supreme Court has pronounced on that point. And nobody can argue that. If the High Court has a case before it, let the High Court continue, and if it succeeds, then it takes its course. But until that time, no, the judgment of the Supreme Court is supreme and must be enforced in Rivers State.
But is it right to say that it is not Uhuru yet? Because again, lawyers have said that the Supreme Court did not address the defection of the lawmakers. So whilst it has said, well, this is a constitutionally, or this is a constituted, legally constituted House of Assembly, but it has not addressed that defection, and so perhaps their legitimacy is still hanging in the balance. Oh,
well, until that is determined, because you need evidence to show that they have lost their seats. Of course, one of the ways of losing your seat is to voluntarily do so, or to defect to another political party where there's no faction, or where you are not expelled, or where there's no division in the party. So if they go back to court and they can prove that the condition under 169 applies, then the court will declare their seats vacant. But until then, they still hold their seats. So we cannot be presumptive, or to say, let's presume what the High Court will say. If actually there is another matter in the High Court about their seats, that issue of defection was not before the Supreme Court, and the Supreme Court cannot pronounce on a matter that is not before it. And remember that during the time this matter was at the Federal High Court, Governor Fubara's lawyers withdrew all his papers. They withdrew his counter affidavit, which could have put the facts before the court. And when that is done, the court will only rely on papers before him. And that is what happened in this case. And the Supreme Court referred to that point, that having withdrawn their counter affidavit, there is no basis for them to bring in facts about defection. So that is very clear, and the Supreme Court judgment should be enforced.
All right, so I want to get to Obiarako in a moment, but I want to stay with you because there is a part of that judgment that says represent the 2024 budget to the House, and until that is done, the allocation will be withdrawn or withheld. If the governor refuses at this point to represent the budget and count on the fact that, look, this case is still in the Federal High Court, would that be a legal thing to do? Can he hang on the fact that, I have a case on the defection of the 27 lawmakers not to represent the budget?
No, that would be very unlawful, and it will consider an impeachable offense, because you cannot spend money from state appropriation, from the state funds, without an appropriation law. And the appropriation law must be properly passed. And that's why the court said earlier on, as far back as December, go back and present your budget, your appropriation bill, before the proper House of Assembly, and it will be adopted. So any money that is spent by the executive, or even by the judiciary, that is not appropriated by the legislature, is unlawful, is subject to be refunded. Even all the allocations and contracts and so on that were paid without the framework for appropriation law, because that's what the law says. And for an appropriation bill to be passed, the House of Assembly had to pass it before you can start spending. Even when there is a need for alteration of the appropriation law, you have to go back to the House of Assembly to do those amendments. So there's no basis to say, because you filed a case at the Federal High Court or whatever, you can now begin to spend money without appropriation law. That is completely unlawful.
Let me get to Obiarako. What's your interpretation of Governor Siminalayi Fubara's statement yesterday, saying that, look, this case is still, in terms of the one that has to do with the defection of the lawmakers, is still at the State High Court, this High Court, Federal High Court rather, in Rivers? Obiarako, can you hear me? So Obiarako, I was asking you what you make, or what's your interpretation of the comment made by the governor referring to the case at the Federal High Court in Rivers State concerning the defection of the 27 lawmakers. All right, so it looks like we have a connection challenge with Obiarako. When we are able to reconnect, we will bring her on just to get the feel on the ground there in Rivers State. But back to you, it's when you, again, to the 27 lawmakers, There are three. So now, what do you expect to happen? Because you have, on one hand, 4 lawmakers. On the other hand, one is a speaker here, and the other for over 4 lawmakers. Another one is a majority leader. However, they have constituted themselves. And then you have 27 lawmakers. Is it a merger? Is it that this is a house that is recognized and this one ceases to be recognized? What happens in this situation?
No, there is only one House of Assembly in Rivers State, and that's one comprised of 31 members. If they have internal wranglings and 4, put themselves aside, and there's 27, it is for them to have internal arrangement. There's always an internal mechanism within the legislature of the state how to reconcile that. But the truth is that there's only one House of Assembly, and the Supreme Court has said that that House of Assembly is the one comprised of the 27 members led by Martin Awulu. And that is the position. Now, if the 4 members of House of Assembly, of course, 27 against 4, you can see the mathematics. If the 4 members want to come back to sit, nobody can stop them from sitting, except if the proper procedure is taken to have them suspended. I mean, this is not the first time this drama is playing out. In many other states, from Anambra to Bayelsa to Ekiti to Edo, we've seen this. And politicians have refused to learn the lessons that you cannot just take laws into your hands. There are rules, even within the House, for suspending members of the House of Assembly. So you must follow those rules. And if you don't follow those rules, set a
precedent, not just for Rivers State, but for other states to know that, look, you cannot decide how many members you want to have in your state to work with in your state House of Assembly.
Of course, because the mandate of the legislators are from the people. The governor or the executive or the president or whoever who is in charge of the executive has no prerogative to decide which member to work with and which not to work with, which members of political parties to work with and which not to work with. That is completely illegal because the mandate is from the people. And once you sideline a member of the House of Assembly or a member of any legislator, you're actually depriving the constituency where he comes from their proper representation. And that is very unlawful. That's constitutional democracy, that all the people have to be represented. If the person is not representing them well, the people will recall him or her. But you cannot sideline the person. And that's what the Supreme Court has re-emphasized in Rivers State, that selecting 4 members and going to sit with them in hotel rooms or wherever is completely illegal. It is completely unthought of. And I think the Supreme Court was very correct in doing that, saying that.
So for those who do not, because for people who are in their mind, they say, but they defected. If they defected or allegedly defected, because they have said that even the APC has come out to say they don't have them in their register until that is proven by the case in the case at the Rivers State House of Assembly, but Rivers State Federal High Court. But I wanted to ask you, for those who are wondering, I mean, if they defected, shouldn't they just lose their seat? What is the procedure? For if somebody says, oh look, I'm moving from this party to this party, what is the procedure to declare that seat vacant?
Well, it's the presiding officer that has the primary responsibility to do so. So if the person announces, because normally if you defect, for you to defect effectively in the floor of the House, you have to announce, you have to submit your papers of your defection, a new party, to the leadership, that is the Speaker or the President of the Senate, as the case may be. So it is for that presiding officer to decide to ask questions. Okay, did you comply with the provisions of the Constitution, which I said is, first of all, you must show that there is a division in the party and that there's a faction and or that you are expelled from the party on which platform you were elected into seat. Now, if you are not able to show that in your submission, the presiding officer has a mandate to declare your seat vacant because you have not complied, because you have cross-carpeted. Now, if the presiding officer does not do so, then anybody can go to court. Anybody from the constituency or the person being represented can go to court for court to make such declaration. And once that declaration is made, the person loses his seat and the court will order INEC to conduct a by-election. But until that is done, the person is still occupying his seat until there's such an order from the presiding officer or from the court. So that is a procedure.
So we will move to other parts of that judgment in just a moment, but I wanted to also ask you, what people have been talking about, like you mentioned, it's an impeachable offense. People have been saying, look, one of the issues that, was an issue of concern where we saw the State House of Assembly blown up, and all of the, rioting and violence we saw in Rivers State, was the issue of impeachment. And then the question I want to ask you is, whilst there is still a case at the Federal High Court in Rivers, do the members of the State House of Assembly who have now been, in quotes, I'm using the word reinstated, do they have the legal standing to say we want to start an impeachment process? Well,
yes, if they can follow the procedure. There is procedure for impeachment, serve notice, Chief Judge will appoint a panel and they investigate and table a report. Why not? Because they have the majority. Now, whether the matter pending in the High Court about their defection can stop that depends on if the court makes an order to that effect. If there is no order that you should stop any process of impeachment pending determination of the suit, then of course there's no such limitation for them to do so. But I think in Rivers State, for the interest of people of Rivers State, they must find political solution to the problem. Governor Fubara cannot continue to sit in the high house because he knows that most of the actions he are taking out of desperation were unlawful. So it is now for the elders in Rivers State to find a political solution to the problem. And impeachment and crisis continue.
From his comment yesterday, it didn't seem like he was looking for a political solution. He said they are going to study the judgment, and then they also referenced again the case that I've been referencing, the one at the Federal High Court. It didn't seem like he was looking for a political solution. It felt like we still have to look at this judgment and see if there are things that we can hold on to. At this moment, because people have said, look, if he decides to go for a political solution, he will be negotiating from a very weak point.
Yeah.
So what do you think he should do now? But I will put you on hold. We'll take a break, and when we return, that conversation will continue. Stay with us. Regarding the different developments in Rivers State, one on the 27 lawmakers, another one on allocation, stopping allocation to the state, and then the one on the local government election that was held there last year. And all of those judgments we've been analyzing here in the studio, but we are joined by constitutional lawyer Chino Obiagu-San, who joins us in the studio, and also on Zoom we're joined by President of Citizens Quest for Truth Initiative, Obiaruko Ndukwe. Thank you both for staying with us. I'll put you on hold. Let me bring in Obiaruko into the conversation. I know that I asked you a question just before the break, but I'll let you speak to it. Obiaruko, what do you make of the governor's statement yesterday talking about the case at the Federal High Court regarding the defection of the 27 lawmakers?
It's actually very funny when people still talk about the Federal High Court and all that. The Federal High Court is the lower court. The Supreme Court has decided on that. In that 1 hour, 36-minute judgment delivered by Justice Emmanuel Akomaye, the panel of 5 men said unanimously dismissed the cross appeal filed by Governor Steve Fubara challenging the validity of the House of Assembly presided over by Martin Ameule as the Speaker. And so what are we talking about? When they are talking about the validity, it means that the governor challenged their membership based on the issue of the so-called alleged or purported defection. And so the court overruled him and said, no, there's no such thing. The court said, there's no issue of defection. It's not there. The apex court held that the actions of the governor over the alleged defection of the 28 members of the assembly is an act of brigandage and dictatorship aimed at preventing the House from performing its legitimate functions under the speakership of Ameule. So I don't know what any other person is expecting the Federal High Court to do. We cannot put the Federal High Court judge in a situation where he will do something that will affect his job. The Supreme Court has dealt with that matter. Even before now, the Appeal Court had done so. The issue of defection, it's not there. It's only if the matter, assuming they had filed the matter earlier on at the Federal High Court, distinct from that of Omotosho, and then gotten judgment. Unfortunately, they delayed, they decided to do what they are doing, and then the Supreme Court has given judgment. Don't forget that last week, when the matter came up, the one filed by 3 members of the assembly, the judge said, we have to wait for the decision of the Supreme Court so that we will know what we're doing. And the Supreme Court has spoken. Unfortunately, people are making comments because it's either they were not listening, they were not present in court, or they are not yet to see the details of the judgment. And I can tell you for sure, by Monday, Tuesday, the enrolled order will be out and all these things will be crystal clear. So for me, people should stop, taking us back. The defection, as far as I'm concerned, was not there in line with the law. But I'm not even the law, so the law has spoken, and so everybody has to abide by it. So,
Oberiko, but you've heard. I'm sure that you've. Oberiko, just a minute. I'm sure that you've listened to lawyers, even the senior advocate of Nigeria, who is with us here in the studio, saying that the Supreme Court did not address the issue of defection, and so that that validates the suit at the federal high court.
Let me tell you something. Let me tell you something. The sequence of events. When the matter was first filed at the High Court, the issue of defection, was not there. But don't forget that the vacancy purportedly created in the seats of the 27 lawmakers was as a result of the purported defection, which made Edison Ehie to declare their seats vacant. So it was before the High Court. When you talk about the vacancy, what would have made them to lose their seats was the issue of the defection. That the word defection was not used. It's neither here nor there. So when they said their seats were declared vacant by Edison Ehie, while the matter was pending, Edison withdrew from his membership of the assembly, the governor withdrew his processes. And so the court gave its judgment and said, these people are legitimate. In fact, let me tell you something. The appeal court was even harder. They came hard on the governor and they said the governor did not show reason why he had to present the budget to a 4-man assembly because there was nothing in the records that showed that Amehule was no longer the speaker. You need to read the 95-page judgment of the Court of Appeal and you will see these things there clearly. Maybe if
so are you saying, Oberiko, because I want the senior advocate of Nigeria to respond to you, but are you saying that whatever judgment the federal high court will give is unnecessary, and so the lawmakers are not obligated to abide by it?
That the lawmakers are what?
I'm asking you that, are you saying that, look, whatever the judgment that the federal high court is going to give as regards the defection of the lawmakers is not necessary, and so the lawmakers are not obligated to abide by it?
No, it's clear. The Supreme Court has spoken. Everybody must abide by the judgment of the court. I mean, whatever the federal high court is going to do is just going to be an affirmation of what. In fact, they are going to tell you that they no longer have jurisdiction because it's what the lawyers call is being overtaken by events. So it's a mere academic exercise, that matter. The issue has been dealt with. If you followed the judgment of the Supreme Court, you will see it's clear. It's very clear that the fact that the governor was referring to their alleged defection, and that's the reason why he refused to present the budget to them, it was described as an act of brigandage and dictatorship. So that what again does anybody know?
All right, so I want the senior advocate to respond to you before we move to the issue of local government, because that's also very important. I want you to respond to her because she has said that, look, it has been decided. There is nothing that the federal high court is going to say on this, and perhaps even preempting the federal high court to say they are probably just going to say, look, it's been decided, and this is an academic exercise. How do you respond?
Well, like I said, I've not seen the judgment of the Supreme Court, but from media reports, the issue of defection was not the core issue in this case, right from the Federal High Court Abuja to the Court of Appeal Abuja and to Supreme Court. And the mere fact that when somebody defects or alleged to be defect, there must be a declaration of his seat vacant for him to say he has lost his seat. And I said the declaration is either by the speaker or the presiding officer or by the court. Insofar as no court has said they have not defected or they have defected and therefore lose their seat, of course, the court still has jurisdiction to do so. If they go back to the Supreme Court, to the Federal High Court and present evidence, because you must present the evidence of defection, present evidence that they've left People's Democratic Party from ward level, and they are now in the register of the new party upon which they were not elected into the House. Then the court will make a declaration. Without that declaration, it is very presumptive.
So the worry is that if the Federal High Court were to make any pronouncement today on the legitimacy of the 27 lawmakers, and if perhaps it's not favorable, that from the way Oberiko was speaking, that they might not abide by it, because it looks like they're going to hold on to the judgment of the Supreme Court to say it is final.
Well, the report coming in from the Supreme Court decision is that in the cross appeal filed by Fubara, he alleged that they have defected. And because of that defection, that's why he sidelined them. And my understanding from media report is that the Supreme Court said, no, we cannot deal with that because there's no evidence before us to say that they are defected. And that's why the cross appeal was dismissed. So the merit of whether they are defected or not was not decided in the cross appeal because there was no evidence to that effect. If they now go back and can prove in the Federal High Court that there was a defection, and the court said, yes, there was a defection, and declare their seats vacant, all they can do is to appeal against that judgment. Because they can simply say, even the Supreme Court said, no, you have not defected today, and you go tomorrow and defect. The Federal High Court can also declare your seat vacant. All you can do is to appeal. So you cannot hold on to a Supreme Court judgment that says, oh, we don't have any evidence that there was a defection, against a judgment of a court. They said, we have now evidence and we can prove there was defection and you have lost your seat. So the point is that, is there a declaration that they have lost their seat? And if the answer is no, then they are still valid members of the House of Assembly.
All right. So let's move to the issue of Rivers State, the local government elections. I will get to your thoughts on it, but I want to get Oberiko's thoughts on it first. And what do you also make of the judgment on the Oberiko? I'm speaking to you now. Of the how do you interpret that judgment on the local government election that was nullified? Oberiko, can you hear me? I was asking you for your interpretation of what you make of the judgment on the local government election.
Oh, the government, I mean that was the Supreme Court.
The Supreme Court nullifying the local government election.
But it was the High Court that the party in the state that changed the paper. And the High Court, before that the elections were conducted, the court had actually asked the INEC to and then also asked the Supreme Court to provide and all that. So, and then the government also and met with that. Just matter of the High Court, I mean, as the appeal court, the favor the government and tell them.
Your network seems to be shaky. We'll come back to you perhaps when we can hear you clearly. Let me get to the senior advocate. When you look at, because one of I was speaking to one of the legal advisor for one of CSOs in Rivers State yesterday, and he said something. He said that he doesn't quite agree with that part of the judgment, but that, of course it's final, but for him, state electoral commissions are independent of the Electoral Act. They don't abide by the Electoral Act. They're not subject to the Electoral Act. So because of that, that shouldn't be, that judgment wasn't for him the right judgment. What do you make of that?
No, that's not true. The Electoral Act regulates elections across the country. The state can make their own laws and regulation with respect to aspects for which the Constitution allows them to make laws. Issues like voters register under Section 50 is regulated by Electoral Act. The State Electoral Commission do not compile their own voter register. They have to rely on INEC voter register. There are so many other areas, even issue of electoral litigation, adjudication is governed by the Electoral Act. Electoral Act is a federal law applicable across the country. And so state normally requests from INEC the voter register upon which they can conduct the election. And there are rules about this. You must stop registration at a certain time before the election and publish the voter register and so on before the election goes on. And that is the basis of the Supreme Court saying, no, you didn't comply with the rules regulating management of electoral voters register. And if you don't, electoral laws is sui generis, and you must comply with every step. And if you don't, the entire process, the entire election is nullified. And that's what happened in this case. So with respect to voter register, Supreme Court has said that, well, both the High Court, Federal High Court, and Court of Appeal and Supreme Court has said that the Rivers State Electoral Commission did not comply with the rules regarding voters register. And that's a good basis to nullify the election.
All right, let's bring in Oberiko one more time and see if we have a better connection with her now. I was asking you for your reaction to the judgment on the local government election, nullifying it. And then what this means, because I was speaking to one of CK yesterday, and he insists that because of that judgment, they remain, they who their tenure was elongated, remain chairman of local government. And I just also want to get your reaction to that comment.
Oh, actually, listening to two of them are before, prior to the judgment of the Supreme Court or local government, it's not taken out of a 10 year that they have hindered the of the Rivers State as regards the local government because it's clear that it was clear that the government was prepared to. So what they did was to go on the provisions of the law that empowers the people to authorize the president for an extension of 6 months at a time. Where the law based on so and then the Supreme Court also, when they gave that judgment for local government, they actually validated what Maggie and the constitutional minister have done by saying that if one can afford to get the chairman or lose next year, what the government also have done was to rely on the sections of the law to do the things that was happening at the president. Explain the tenure of elected chairman, the emphasis on the elected.
All right, Oberiko, again, the network is not helping us hear you clearly. I can pick one or two things from what you have said, but putting them together is a bit difficult. So because of the time, just for that reason, we do have to let you go because we have very limited time. We can't keep doing the connection back and forth. Thank you so much for your time. President of Citizens Quest for Truth Initiative, Oberiko Ndukwe. Thank you. Well, let's, she was, at least I could pick a thing or two from what she said, talking about, she was saying elected chairman. And it's what I want to ask you, because now those whose tenures were elongated, and then we saw all the fights at these different local governments just before this judgment. They are insisting that because of this judgment, they also remain the chairman, because now that this State House of Assembly has been legitimized by the Supreme Court judgment, because they were the ones that elongated that tenure, that also remains. But put that side by side with the local government autonomy judgment that was also given by Supreme Court, and explain what that means for them.
No, I mean, the elongation of tenure is completely unlawful, because you cannot elongate the tenure unless you amend the law that creates the tenure. Section 7 has said that local government of the Constitution has said local government must be governed by democratically elected officials. So, and the state laws put the tenure of each local government. So once that tenure is finishes, the bar is closed. So you cannot now by a resolution begin to elongate it unless you amend the law too. So what happens is that now the Supreme Court has said this election of the local government people, chairman in October was not properly conducted. Then it is for the Rivers State Electoral Commission to declare those seats vacant and conduct fresh elections. But in the interim, the head of administration in the local government will take over
I was going to ask you about that, because that's where the conversation has, everybody has been talking about what happens, who fills the vacuum. You can't have caretaker chairman. What then happens at that level in terms of administration?
Oh yeah, the rules are clear. The head of administration in each of the institutions or local government will take over administration pending the time, either the 60 days window or 90 days window, according to the law, of the Rivers State electoral law. For the Electoral Commission of the state to conduct a fresh election, because the Supreme Court has said that election conducted in October was nullified. So there's nothing anybody can do about it. And it is very far-fetched to now say that previous officials who were purported to have been elongated will now come back to sit without being elected afresh. No, that is far-fetched. I think the law is clear, and the Rivers State Independent Electoral Commission should follow the law and abide by the ruling of the Supreme Court.
Are you concerned, in how, because of the interpretation, because it's been different interpretation from all parties since yesterday, that perhaps people might want to take laws into their hands to say, let's want to enforce because of their own understanding or how they have chosen to interpret this judgment, take laws into their hands and say, we want to want to go back to our office as local government chairman, or we want, we remain, if the Federal High Court gives another, judgment, we are not going to abide by it. Are you worried that this illegality could continue?
Oh, yes, I'm worried, because right now, and that is my worry, that Governor Fubara has not chosen a political solution. If the governor and his administration not take steps to pronounce what happens now, there may be looting at local government. There may be all kinds of things at local government, because now the current chairman and councillors have lost their seat. The election is declared null and void, and so they must vacate. And then when they vacate, you cannot ask those who were previously to come and take the vacuum. It is not done. It's unlawful. So the head of administration must take charge until fresh election is conducted, and the state government must give that directive now, so that there won't be anarchy at the local government headquarters. And that is the responsibility of a governor. Forget about selfish interests. Once the law has been pronounced, the governor has a responsibility as the political leader of that state to make sure that there is order. And the only way to do so is to put sanity, give clear direction, even if it is against his own interest, because that's why he's a leader. Probably,
again, I mentioned earlier that right now it looks like he's going to be negotiating from a weakened position. I might not want to do that. But how in terms of political solution, what do you expect him to do? And then should he relate with now the State House of Assembly? People have said, look, pay them all their entitlements, everything, all the way from when this issue started till now.
I think the only way he can save his seat, with all due respect to the government, is to abide by the law. Now, once you abide by the law and make sure that everything you're doing is lawful, even if there's a purported impeachment, the court will reverse it. We've seen so many cases, in Pitobi and in Gige, in Anambra State, in Bayelsa, and many places where if the House of Assembly proposed to impeach a governor without following the rules, without proving that the governor has committed an impeachable offense, the court will reverse it. So if he continues with the illegality, then there's a tendency that he shoot himself on the foot. But if he complies with the rules, properly advised legally, and make sure that everything is done in order to save governance in Rivers State, I don't think he will have any problem. Remember too that there are a lot of factions apart from Fubara and Wike. There are also other factions there. He could also build alliances with other political forces.
You don't think that that's too late now, considering all that have been said and done? I mean, a lot of comments and statements were made. Some said he has missed the opportunity where he could have, look for a political solution, especially because the president also waded in, at some point.
Precious, there's no situation that is unredeemable politically. All you need is have proper negotiations, sit down at the round table, and in politics they say there's no friends and no foes. And those who are foes yesterday could be your friends today, depending on how you play your cards. Now, if these House of Assembly members have come back and the governor calls them together and says, okay, can we work together? And they work it out, but still be on the high horse even when the Supreme Court judgment is against you, it doesn't give you the opportunity to do so.
You know that, I think I have like 30 seconds left, but you know that you can't, he really can't do anything until, this house, these 27 lawmakers probably will refer him to Wike and say, look, we have to work with you. You have to go to Wike, probably, and say, look, settle with him, and then we can have a deal. And
I don't see anything wrong with that. Wike is a human being, he's a lawyer. There's nothing, I'm sure that he has interest of Rivers State at heart. So, he wouldn't like anarchy to continue. There's nothing wrong with that.
Well, interesting days ahead. We'll see how the governor said he's still studying the judgment, and then also the one at the Federal High Court, he has referred to that as well. We'll see how things play out in Rivers State.